Hi, greetings. It's me, Dr. Paul Gerhardt, and in this labor relations and collective bargaining video, I want to talk about unfair labor practices and contract enforcement. And again, no matter what it is that you do for a living, if you are dealing with employees of a union, or if you are in a union, you really have to understand what laws are out there and the consequences for violating each of those laws. So some of the things that we're going to talk about in this video is about interference with employees' rights to organize, the discrimination against union members, protected activities, duties to bargain in good faith, rights and prohibited conduct during a term of negotiation, authority of the National Labor Relations Board, public sector unfair labor practices, contract enforcement, and individual rights within unions. So let's talk about unfair labor practices. The National Labor Relations Act, Section 8A, lists employer activities that are considered unfair. So, interference with, restraint, or coercion of employees' rights are guaranteed under Section 7. Domination or interference with the formation or administration of a labor union, discrimination against union members for their union membership, discrimination against an employee for pursuing the rights under the Act, refusal to bargain collectively with representatives of its employees. It really is very, very important that if you're a manager, that you've got to be able to respect the rights of union members and the right to discuss becoming a union. Some unfair labor practices that interfere with the organizing of a bargaining unit are specified under the National Labor Relations Act, and so they're protected under the NLR Act, NLRA, and that includes solicitation and distribution, union buttons or insignias, bulletin boards and meeting halls, email solicitation, employer rules. The Nlrb has determined that certain activities during an election that constitute violations of the Act include campaign propaganda and misrepresentation, threats and loss of benefits, promise or grant of benefit, interrogation and polling employees, interrogation and I don't know why that's so hard, sorry. Interrogation and polling of employees, surveillance, poll activity. There's something called the goodness gracious, lost my notes here. Called the 24-hour rule, which specifies that, I'm going to read it here, for manual elections, the understanding rule followed by the NLRB has been that captive audience meetings are prohibited within a 24-hour period before the start of the election. The rule means that employers have 24 hours less to address union election issues with employees. All right, so let's talk about good faith and reasonable doubt, or good faith, reasonable doubt. An NLRB rule that provides an employer who entertains a good faith, reasonable doubt that the employees support the incumbent union may request an election, withdraw recognition and refuse to bargain with that union, conduct an informal poll of employees. Typical unfair labor practices in an organization campaign include employer domination and interference. So here's what that is. Under the National Labor Relations Act, in addition to campaign-related violations, employers' domination of and assistance to labor organizations are also employer unfair labor practices. The unlawful domination and assistance pertains only to labor organizations. So, other unfair labor practices by employers, the employee teams and the NLRA, Discrimination, that's 5 action committees created by the employer ruled to be employer-dominated labor organizations. DuPont, employee management committees that dealt with safety and recreation ruled to be employer-dominated labor organizations. And employer support and assistance, support assistance to a favored union that affects the employee's exercise of rights guaranteed by the NLRA. So, let's talk about discrimination against union members. It's a violation of the Act when an employer encourages or discourages membership in any labor organization by hiring or has tenure practices or by using membership as a term or condition of employment. And discrimination occurs when a union member is treated differently from a non-union worker because he or she is involved in a union activity. So that's a slippery slope. So organizations really need to be very, very careful about how they interact with employees. Some protected concerted activities include any legitimate action taken by employees to further their common but not individual interests, such as wages, hours, and working conditions, and to establish concerted activity. The issue involved must be work-related, and the goal should be to further a group interest, specific remedy, or result in sought. The act itself must not be unlawful or improper. They have a duty to bargain in good faith. They can refuse to bargain, but the labor organization is obliged to bargain in good faith, must have an open mind in a meeting and conferring with the employer, and must sign any agreement that both parties have agreed upon. And demanding status of exclusive bargaining agent for an appropriate unit is an unfair labor practice. So let's talk about strikes a little bit. A strike is a type of concerted activity protected under the Act if it's called for economic reasons, which is also called an economic strike, or to protest unfair labor practices. Unfair labor practice strikes is what that's called. An illegal strike is a sit-down strike, a wildcat strike, or a partial strike, or a strikeout. So, strikes provide unlawful ends to make a strike illegal. There's jurisdictional strikes, feather bedding strikes, and recognitional strikes. Look them up. Weingarten Rule. This is a rule that was developed from this case decision holding that a union employee may request the presence of a union employee request the presence of a union official during questioning by management in a disciplinary situation. So you have to know if employees that are working for you, if you're a manager, they have the right to request the presence of a union official. And if you are a union employee, obviously you need to know that you should be able to ask that maybe it's your union steward be present. So they can't conduct any kind of disciplinary action until that person becomes present. Union restraint or coercion of employees is illegal in actions that violate the Taft-Hartley amendments to the NLRA. It would include physical assaults or threats of violence, threats of economic reprisal, mass picketing that restrains lawful passage to the workplace, causing or attempting to cause an employer to discriminate against employees, and discriminating provisions in collective bargaining agreements. The authority of the NLRB includes an unfair labor practice charge goes to the NLRB through procedures similar to election procedures. And a party who disagrees with the NLRB decision can appeal up to a federal court. So the NLRB reviews unfair labor practices charges. And there are regional offices where claims are filed. Hearings are held for administrative law judges or J's. They try to fashion informal settlements. The ALJ decision may also be appealed to the National Labor Relations Board, and NLRB decisions may be appealed, as I mentioned earlier, to a federal court. So some dispositions of 2009 show that most settlements and adjustments were about 36%. Withdrawals before the complaint were about 32%. Dismissals before the complaint were about 28%. So that's some quick information to understand. Sometimes things get settled before they go anywhere in a more legal binding process. Unfair labor practices in the public sector. The Federal Labor Relations Authority, or the FLRA, administers and enforces the Federal Labor Relations Act. Unfair labor practices are defined similar to those in the private sector. And unions and government agencies are subject to unfair labor practice charges, and unions file about 95% of all unfair labor practice charges. So some other unfair labor practices in the public sector information that you need to know is the FLRA undertakes intervention techniques to assist in resolving disputes when numerous charges are filed by the same parties. Both parties agree to the intervention process. Both parties are committed to resolving their disputes. Charges concern institutional and relationship issues. They experience both parties, suggesting that intervention may be useful, and the central office of authority will provide support. Some court injunctions need to be understood. Section 10J permits the NLRB to seek federal injunction using this following criteria: union organizing, campaign interference, subcontracting work to outside employers, withdrawing recognition of a union, undermining the members of the union's bargaining team, granting exclusive representation to a minority union, and successor employers refusing to recognize and then bargain. So, bad faith conduct during negotiations, picketing violence, strike or picketing notice or waiting period violations, employer refusal to allow protected activities on private property, retaliation for NLRB processes, the close down or operations during litigation, and then union coercion to achieve unlawful objects. So lots of things are decided upon. It's at precedences in the court systems, but it really is important to understand both sides of the National Labor Relations Acts, and everybody really, again, should be working in good faith to make sure that they're being lawful, and it's your job, if you're a human resource personnel, to make sure that managers are making the best decisions possible, and then of course treating employees in a positive, objective way that of course is lawful. Anyway, thank you so much for your valuable time. I hope you have learned something in this video, could take something away that's useful to you, and even more than that, I hope that you have a great day, because only you get to choose how you feel about it. I'm Dr.